So, I am a magistrate judge, and I've loved making this transition. I love being an advocate. I was honored to be a federal defender and to work with Jim and others on sentencing reform issues and to be in the heart of the criminal justice system. And I feel like coming in through a different part of the courtroom and sitting in a different place is a very shocking and different experience, but it's still a wonderful one to be part of our system and to try and play a role in public service. You know, one of the great things about being a magistrate judge is that I'm not faced with the incredible challenges that Judge Marbley is in sentencing people to 20 and 30 years in prison and being faced with mandatory minimums. And I certainly, as an advocate, was on the other end of that. And I'm happy to talk about sentencing, even though my sentences usually are measured in a weekend for driving drunk on the GW Parkway. By the way, just a note, that's all federal land, so if you're driving on the GW Parkway, it's coming to my court. I do think, however, that issues of implicit bias, issues of racial disparity in the criminal justice system is incredibly important. It's incredibly important to me, even though I'm not in a position of having the authority or the position to hand out 30-year sentences. But I think we see that these issues start at the very beginnings of cases for a whole variety of reasons, and I've seen it even in the 7 months that I've been on the bench. Magistrate judges deal in felony cases, as I'm sure all of you know, with initial appearances. It's different in federal courts and what jobs are given to magistrate judges, but in our court we deal with initial appearances, detention hearings, and preliminary hearings in felony cases. And of course, something that we know and the literature shows us is that that initial determination as to whether or not a person is locked up pre-trial can have an enormous impact on the back end, not only into how a case is resolved, all of the pressures of having to make a decision when you are separated from your family and dealing with your attorney only when he or she can come meet with you in the jail or speak to you on the phone as opposed to being at home, but also, of course, the ability to demonstrate to the court that you can keep a job, rehabilitate yourself, do things that it's simply impossible to do if you're in the jail, even if you're lucky enough to have access to programs within the jail. And so I think sentencing is where the tough decisions are made, but oftentimes those decisions are informed by what's happened starting at the very beginning of the case. And you know, I certainly saw reference to both explicit and implicit bias in the criminal justice system. I certainly have not seen explicit bias on the part of prosecutors or defense attorneys, and certainly I've tried my best not to have any explicit bias. But the reality is when you get a pretrial report, and those of you who are prosecutors and defense attorneys and the judges here, I'm sure, have had this experience. When you see a pretrial report and make that initial determination as to bond, you're looking out into the courtroom to see if family is there. You're looking to see if there's a letter from an employer. And all of a sudden, the capacity for someone who comes from a more impoverished background is going to make it more difficult for them and for their lawyer to demonstrate that there are conditions of release that can be fashioned. And so you see on that release issue that there is a racial impact, and that those people without means end up having a harder time getting out and being able to demonstrate that they can abide by the terms of their supervision. So I think as advocates and as judges, we have to think from the very beginning about what we're doing and be conscious of the decisions we're making as to whether or not we think that there are conditions that can be set. Let me say on the issue of sentencing, and I don't want to take up too much time, in the post-Booker world, of course, from the defense perspective, there was this sense that there was an enormous change on the horizons, that lawyers could actually begin to be lawyers again and ask judges to impose sentences based on their individualized circumstances and that the guidelines wouldn't dominate. As we've seen, and as you see around the country, the guidelines still continue to play an outsized role in the sentencing function. And many judges think that that's appropriate and not a problem, and I think others probably see that it's a vestige, that it's hard to get away from old habits, and that sentencing shouldn't be a process of subtraction The determination should be what amount of jail, if any, should be imposed in the first instance, and that might or might not correspond to what the guidelines come out to. Of course, the most powerful example of that was the crack powder disparity. And I had the privilege of arguing the Kimbrough case in the Supreme Court, and give the credit to my colleagues who did all of the work, including Jim and many others in the defense community for many years before that, so that it's perhaps the greatest example of implicit bias, which is that at the time that 100-to-1 ratio was determined, when Len Bias died in 1985 or 86, and of course he died of a cocaine overdose, not crack, there was hysteria over the menace that crack posed, and all of a sudden, for the first time in history, a drug that was pharmacologically identical, crack and powder, the way it was simply a punishment based on the method of injection or ingestion, was what determined the punishment, ended up with one of the most pernicious and corrosive examples of unfairness in our criminal justice system. You had the lowest level retail dealers of crack cocaine, who are overwhelmingly African American, being punished far more harshly than the wholesale managers and providers of the raw materials to make that, who were overwhelmingly white and Hispanic, and it took almost 20 years to fix that problem. I think that to the extent there are any changes in the division of sentence based on race, that you can go back to looking at mandatory minimums, and you see a dramatic racial disparity in the use of mandatory minimums in communities of color as opposed to the white community. So to a certain extent, if judges are imposing slightly longer sentences in the aggregate in the African American population, that can almost certainly be traced to having their hands tied still in certain cases. Now, we see as the Department of Justice has shifted its priorities and is using mandatory minimums less based on the Holder memo, and now with Loretta Lynch as Attorney General, that maybe that will change. But, I was an advocate for sentencing discretion being placed with judges and moved away from prosecutors and advocates. Now that I'm a judge, I believe even more firmly the discretion rests with judges. But having said that, I think the judges have to recognize that they are no more immune from implicit bias, and sometimes even explicit bias, than anyone else in the system. And that includes defense attorneys, and I think I heard the president of the ABA make that remark. And I will say that there is education going on, at least in the federal judiciary, about implicit bias, and the FJC and the AO, I was just over there this week, are doing programs, and they do these studies that maybe some of you have done, where you have these questions being asked, and people who think they have no bias whatsoever will associate a firearm with African American people and not with white people. It is amazing psychologically how people will be affected by these things without understanding how it's come about or where it's come about in their brain or cultural background. So I think judges need to be very aware of it, along with everyone else in the system.